of doing the law degree is, things you've learnt about law that are also valuable in life more generally. And I think one of those things is that there's an important difference between being mostly right and being right. Okay? So, law, like life, is very complicated, and there's a lot of it. So to get through it, people adopt things that are easy to remember and are mostly right. Okay, and if something's mostly right, then most of the time it will be fine, and most of the time it will work. Okay, but what's the problem with things that are mostly right? What's the problem? Something that's mostly right?
Sometimes it's not right.
Yeah, exactly. It's not always right. Sometimes it's wrong. So you use this thing that's mostly right, and most of the time it's fine, but every so often it will be wrong. Okay? And actually, when you think about what you study in law, and in particular the cases we focus on, the cases we focus on are precisely the interesting ones where there's something special about the facts, and those facts often test the limits of ideas that are mostly right. And it's in those cases, which in one view are unusual, but actually tend to be the ones that lead to the appeals and that lead to Courts of Appeal, Supreme Court decisions. Those are the cases where you realise that the thing that's mostly right, in fact, can sometimes be wrong. Okay? So I think an important lesson that you get from law is that naturally, to get through things, we use the easy stuff that's mostly right. But you have to be aware, if you're going to use those things, that if they're only mostly right, sometimes they're going to be wrong. And what would it be better to use rather than the things that are mostly right? What would be a better thing to have if it were available?
Always be right.
Yeah, things that are always right. And that's what you come to a good law school to learn, is you want to learn things that are always right, not the things that are mostly right. Okay? But in practice, like in life generally, people rely on the things that are mostly right. Okay? And there's a whole, discipline where people explore the limits of things that are mostly right, and they say, look, we make these assumptions, and most of the time these assumptions are right, but in particular cases they're wrong, and that reveals to you the limits of those assumptions. Okay? So lots of the sort of behavioural economic stuff is about that. Lots of the Kahneman, Tversky stuff is about that, things that are mostly right. Have you come across this? What Kahneman, Tversky stuff, this isn't about law, this is just about general knowledge, so it doesn't matter if you haven't come across it. But they have this idea of heuristics that people use. Like people adopt ways of thinking about things because those things are mostly right. Okay? And there might be sort of evolutionary reasons for thinking about things in that way. Okay? So you think, if it rained for the last 3 days, you think it's going to rain today or whatever. But then you think, oh well, the number 12 came up in the lottery the last 3 times. It can't come up again. Okay? And is that right to say if the number 12 came up in the lottery the last 3 times, it can't come up again today? Is that right? No. But people sort of think like that because it's easy to think if things happened before, they're either less likely or more likely to happen again. But the things that are mostly right are precisely the things that can be very dangerous because they lead you to the wrong conclusion in those minority of cases where they're wrong. So a lot of what this work is doing is to say, beware the things that are mostly right, because sometimes they get you in trouble. Okay? Now, this is what basically assignment's about, and I think it's what a lot of commercial law is about, because commercial law, people are very practical, they're very sensible, they want to get on with things. They're quite happy to use these ideas that are mostly right. Okay? And if you want to sort of talk to people and not annoy them and not appear very pedantic, you have to sort of go along with that. Okay? You have to sort of talk the talk. But you should remember that these things that are mostly right, they're not actually right, and sometimes it will matter that they're wrong, and in those cases you need to be able to go to that other level and come up with a thing that is actually right. Okay? And that's a lot of, I think, what doing law well is about. Okay, so people say things like, oh, well, you know, contracts are about agreements. Okay? And that's mostly right. Like, most of the time that'd be fine. But there are some cases where you can have a contract where there hasn't been an agreement. Okay? So if you say contracts about agreement, that's sort of fine as long as you know that that's not always going to be true. So when can you have a contract without an agreement? Do you know any famous contract cases?
Maybe if there's a standard form contract.
Yeah, I mean, standard form one, that's a good example. I mean, I suppose with the standard form one, you might say, well, you know, you signed the document or whatever, therefore there's an agreement. But you're right, if you sign, the rule is, if you sign the document, you're taken to have agreed to it, but you might not actually have read it. You might not actually have agreed to it. Like when you're, you know, ticking a box on the internet that says you consent to the terms and conditions. I mean, have you really agreed? Do you know what the terms and conditions are? No, but it's still binding. Unilateral contracts as well. Unilateral contracts aren't agreements, they're still contracts. Okay? But the idea that contracts are agreements is quite useful because it gets you through most things, but you have to be aware that it's not always right, because there'll be some cases where it makes a difference. Okay? And we'll see this with assignment. I mean, this is an important lesson with assignment, I think. So, what's an obvious synonym for assignment? What words mean the same as assignment?
Ascribe.
Sorry?
Ascribe.
Yeah, ascribe can mean it, that's true. Like if you're assigning something to someone, you're assigning a quality or a description to someone, it can be ascribe. In January, if you're interested in football, why is January interesting?
Transfer window.
Yeah. So we could, and what else could we call the transfer window? The assignment window. Think of it as the assignment window. Assignment and transfer are often used as synonyms. Okay? And that process of ascribing is, in essential, transferring a description to something. If you're ascribing a quality to something, you're transferring it. So commercially, people tend to think of assignment in terms of transfers. Okay? And the big question to ask, well, that is mostly right, and that is how people think about it. And you have to realise that people talk about it like that, and you're not going to stop people talking about it like that. And if you tell the partner you're working with in your city law firm that actually assignments aren't really transfers, they're not going to be very pleased. But the question to ask is it always right to think of an assignment as a transfer? Or is it just mostly right? And importantly, if it's only mostly right, why might that matter? When might it be a problem that it's only mostly right? Okay? Now, where have you seen transfers before in law? What sort of things get transferred?
Money.
Money? Yeah, money is an example. That's actually quite a tricky one. Let's try and find something simple to start with. If you want to understand what a transfer was, try and think of something simple. Yep.
Title.
Yeah, good. Title. So title to, what would be an example?
Property.
Yeah, good. So the thing that people think of with transfer is transfer of title. I'm assuming this is a whiteboard, isn't it? Let's just check. So the things that people think of normally about transfers is transfer of title to property. Something like, what would an example be? Simple bit of property.
A house.
Yeah, although that's a bit. You're right. I mean, a house, that's a bit complicated then because you have to say, is it a freehold, is it a leasehold, and it's land. There's special rules about land. Something easy. Yeah, goods. Think of goods. So basically, just think of a thing, like any basic thing, and let's make it personal property to be easier. So give me an example of a good, bit of property that's not a house.
Wheat.
Yeah, wheat. That's fine. So let's say, I don't know, it's a bag of wheat. Okay? It's a bag of wheat. It could be a bag of anything. And let's say that A owns it. Okay? Then what happens if there's a transfer to B? What happens now? Now we would say, look, now B's got the bag of wheat. Okay? But you made the point before that what's being transferred, strictly speaking, is not the bag. What's being transferred is title to the bag. Okay? Because I could give you my wallet and say, please can you look after my wallet? Then you've got possession of it, but you don't have title. It's still my wallet. You don't have my title anyway. You don't have my title. It's still my wallet. So with the transfer, what you're shifting are the rights. Some rights are being shifted. And actually, if you think about it, what's the consequence of transferring title to the bag? What difference does that make to the party's rights? What does it mean? You know, you've all done property 1 and property 2. What happens when you transfer property? What happens to the party's rights? How do the rights change? What did A have before the transfer? Oh, it's at the start. What did A have before the transfer?
Ownership.
Yeah, good. And what does that mean?
Possession. And actually legal title of the good.
Yeah, but what does that mean? Like in practice, what does it mean? So yeah, you've got ownership. Yeah.
Stop people from using it as an
Yeah, very good. Just say that again. You're right. Say it again.
You can stop people from interfering with your goods.
Yeah, exactly. You can stop people. A can stop people from interfering with the goods. Okay. So A has got rights against prima facie everyone to stop them interfering in the goods. So if anyone comes up and takes the wheat, if anyone carelessly damages the wheat, A's got a claim against them, and A doesn't have to show any prior relationship with the defendant. You just say, look, it's my stuff, keep off it. Okay? And I think really that's the key aspect of ownership, is you've got rights against everyone not to interfere with the thing. Okay? So let's think of someone who is everyone, think of X. Okay? So at stage 1, X has got a duty to A not to interfere with the thing, not to interfere with the bag. Yeah? Okay? But then, title's transferred to B, so what happens now? What's X's duty now? Yeah? Yeah, good. Now, it's the same, but it's O to B, that's right. But what's the content of the duty? What is it that X has to do or not have to do? What's the content of the duty? Is it the same as before? Yeah, it's still a duty to keep off the thing. A duty not to interfere with the thing. So from X's point of view, has much changed here when there's the transfer of title? No. Like, people are buying and selling goods the whole time, and as a result, strictly speaking, our duties are changing because we owe duties to the owners of the goods, not to interfere with them. So if someone in the street is selling a bike or something, well, I don't know what people sell on the street these days. Somebody's selling something on the street. Cars, like Warren Street, as you know, there's a used car market in Warren Street. It's in one of the cases that you looked at, I think. So people might be selling cars out there the whole time. And as a result, our duties are changing. Rather than owing a duty to the seller of the car, we now owe a duty to the purchaser of the car. But does that make a difference to us? Do we care? Because what is our duty? What do we have to do in order to fulfill the duty? To fulfill our duty to people who own cars out there, what do we have to do? Don't interfere with other people's stuff. Yeah, and this duty that X is under is a duty not to interfere with other people's stuff. And so it doesn't matter to X to whom they owe that duty. It's no concern to X who they owe that duty to, whether it's A, whether it's B. So from X's point of view, it's fine for A and B to be transferring this stuff. It's no problem at all. And so it's very easy to transfer title to goods. Okay? You don't even have to transfer possession. You can transfer title to goods without transferring possession. Okay? And that's nice and convenient for the buyer and the seller, and it doesn't cause any problems at all for X, because their duty is still to keep off people's stuff. Okay? So what you're transferring really is that right that correlates to everyone's duty to keep off is transferred from A to B, but from everyone else's perspective, it's not really a problem. Okay, so that's what happens when you have a transfer of title to goods. You all right with that? Happy enough with that? Right, now, what we're going to look at is assignment. And what's being assigned? What are we looking at in these couple of lectures? What's getting assigned?
Contractual right.
Yeah, good. Contractual right shows as an action. Now, we've got this idea of transfer that we've developed from the standard case of transferring title to goods. But the question then is, does that carry over when you're looking at dealings with contractual rights? Okay. And so when people talk about assignment as being transfer, what they're really saying is this model that we have for transferring title to goods can be applied to assignments of shows as an action. Okay? That's the way that people think about it. And that's the thing that's sort of mostly right. But the question to ask is it always right? Okay? And you know, that's the reason that you want to do law. That's the reason that people choose to do law, is because you want to be the type of person who's always right. Okay? That's your motivation for doing law. You've got to be a little bit annoying, a little bit pedantic, to want to study law in the first place. Okay? And I think that's how they should select people, really, with a law degree. But so so you should be interested in this question. Okay, is it really a transfer? Okay, so you're right. We're looking at contractual rights. Now, there's a big difference between a contractual right and ownership. What's the difference? You can own a bag of wheat. Can you have a contractual right against a bag of wheat?
No.
No. Who are contractual rights against?
People.
Yeah, people. So, what we're looking at here at the start is a contractual right of A right against X. And let's say that X has got a duty to pay A £100. Duty to pay £100 to A. Okay? So X has got a duty to pay £100 to A. That means A's got a contractual right against X. Okay? Now, if it was possible for A to just transfer that right to B, what would happen? What would be the case now? If you could just transfer that contractual right to B, what would be the case now?
X would owe B 100 quid.
Yeah, B would then have a contractual right against X. And X would be under a duty to pay £100 to B. Okay? Now the first point to note, and this is a point that Tam makes, Chi-Ho Tam, he wrote a doctorate recently on assignment. He's written quite a few articles about it. Chi-Ho Tam, he's got a couple of articles on the reading list. And he did a doctorate on assignment recently, which I was one of the examiners for, and it was very good. And I'm normally quite mean when I examine doctorates. I've got a record of telling people it's not good enough, but his was very good. So he makes this point that even if this is what happened, even if this were true, is that really a transfer? Is it the same duty that X owes at the start and at the end?
No, because it's to different people.
Yeah, good. Initially, X had a duty to pay A. Now, X has got a duty to pay B. So one of the points that Tam makes is, well, strictly speaking, that's a different duty. When we were looking at transfer of title, X's duty at the start was a duty to not interfere with the goods. And their duty at the end was a duty not to interfere with the goods. They were just now owed to different people. Whereas if you go from having a duty to pay A to having a duty to pay B, that's a different duty. So even if this could happen, even if this model were correct, strictly speaking, it's not a transfer. Okay? Because the duty is changing. I think that is right, and that's a fair point to make, although in practice that's not too important. But, you know, he's right to say that. But there's another difference, which I think is perhaps more important in practice, in understanding the law, and that's if we look at X's position. Now, I said with the transfer of title to goods, we're quite relaxed about that, because X's position is essentially the same. Sort of keep off the goods. But now, if you can have a transfer from number 1, where X has got a duty to A, to number 2, where X has got a duty to B, if that can happen just by A and B arranging it, why might X be unhappy? Why might X not be so keen on that A and B, just between themselves, making that change occur? Why would X not be happy about that?
Because X might get a different set of burdens with the transfer or the assignment of the right to be.
Possibly, yeah. It's true that there's a risk that the burdens might be different. Now, if you look at it, you might say, well, it doesn't really matter that much, because in this example, all they have to do is pay £100. It doesn't really matter. I mean, you're right. We'll see that there are some cases, we'll look at these in the next lecture, of contracts that can't be assigned because the law says they're inherently non-assignable. An example of that might be a contract to provide personal services. Okay? So if you have a contract to provide personal services to someone, you say that I will come and, you know, teach you how to play the violin or whatever. They can't then assign that right to somebody else, so that you then have to go and teach somebody else to play the violin. Okay? And there you say, well, look, because what you're being asked to do, the character of it changes according to the person you're doing it for. So those types of contracts can't be assigned. So that's an important point. But the ones we tend to focus on are fairly simple things like a duty to pay money. And these are the ones that are important in commercial practice. Because if you're a company, the valuable contractual rights that you have are generally things like rights against customers that they have to pay you money, rights against your debtors. Those are really, in practice, the important rights. Now, with those ones, the right just to pay some money, we've got less sympathy for X, because we just say, well, it's just paying money. Just pay it. It doesn't really matter who you're paying it to. But it's nonetheless possible for X to object. How might X object? One thing to think about is where did X's duty come from? Now, in the case of transfer of title to goods, X's duty at the start is just a duty not to interfere with the goods. And where did that duty come from? Why are you under a duty not to interfere with people's goods? I don't want some big philosophical explanation, but where does it come from? When did you come under that duty not to interfere with other people's stuff? Yeah, but that general duty, I mean, that would be in relation to specific goods, but just in general, the duty not to interfere with other people's stuff, that general one, where did that come from? Yeah, so it comes to the law of property, it comes from ownership, and the point is you're just always under that duty. Because you're a person in the jurisdiction, you're under that duty. It's just always been there. You never had any say in it. You never chose to be under that duty. But X's contractual duty is different. X chose to have a contract with A and to be under that duty. So X is saying that I had a contract with you, and the reason I'm under this duty is because I agreed to it. And I did not agree to be under a duty to B. X can validly complain and say that I agreed to enter a contract with A. I'm under a duty to A precisely because of my agreement. Now what you're saying is A and B, behind my back, can turn that into a duty to B. And X can say, well, that's not right. Since my original duty was based on my agreement, how can I now be under a different duty that I haven't agreed to? Okay. And that's a good point. That's a valid argument. And this is a problem. Because that argument of X, it doesn't work in the case of transfer of title to goods. But it does work in the case of a transfer of a contractual right. And I think that's crucial to understanding the law of assignment. Because it means you can't just let people transfer contractual rights in the same way that you let them transfer title to goods. Because if you did, you wouldn't be giving due regard to the interests of X, to the interests of the debtor. Okay? So people often say things like, well, you know, contractual right shows an action is property. So Lord Nichols, Baroness Hale, in the OBG and Allen case, which is on the handout, they're the minority in that case, but they both say, look, your contractual right, your shows in action, it's property. Okay? So Baroness Hale there, her definition of property would include a contractual right, include a shows in action. And okay, you know, it might, in some senses, it might be property. It might be right most of the time to think of a contractual right as property, but it's not always right. There are some important differences between a contractual right and ownership of goods. And one of those differences is in where X's duty comes from and the nature of that duty. And this is why the common law has always had this general rule that you cannot assign contractual rights. Okay, the common law has always been very clear